I'm sounding kind of confused because it is confusing because they'll deal with it randomly. Sometimes they'll consider a K-1 visa, although nominally a non-immigrant visa, as an immigrant visa, a person's coming permanently like a marriage agreement case. Sometimes they don't, which leads to number 10, how they deal with these things differently, which is actually an example of that. For example, when the pandemic happened, there was a ban on people who were not, who haven't got a shot or couldn't come to the United States because of the pandemic and all that kind of stuff. They made an exception for people who are spouses of U.S. citizens. Now you think, okay, fiancés are going to be spouses too, let's do the same. But they did it differently. So all of a sudden, fiancés who thought they were going to come faster than marriage cases got stuck outside because they weren't part of the exception for entering the United States, whereas spouses were. So you see how they treat this differently, but in other contexts, they'll treat it like an immigrant visa. So it's a confused matter. And these are all different factors you have to consider when you're making a decision to do a K-1 visa. Now, if you've been listening to this whole thing, you'll probably think and understand, like, I'm not inclined to do fiancé visas.